Magellan Advisors is building networks and smart strategies across the country from some of the most dense urban environments to about as rural of areas as you can think about. And in the process, we deal with a lot of very practical policy issues. So it's really appropriate and really delighted to literally and figuratively come in from the cold here in DC between a panel on rural broadband and a panel on privacy. And let me just give you kind of one little quick example of a project I'm actively working on that is very relevant to this. In a urban core neighborhood that is low income and high minority people of color. And interestingly enough, they have, quote, adequate, unquote, broadband for present purposes. But at the same time, they face huge barriers to not just accessing the technology, but really effectively using it. And some of those are really deep culturally seated. So for example, we did a survey to really understand what their needs and opportunities are. And for anybody that's worked in disadvantaged neighborhoods, you probably know pretty much exactly what happened. They didn't really respond because the folks in these communities, in this particular neighborhood, have been systematically disenfranchised. They don't trust their local government. They don't trust large corporations. They don't trust consultants coming in and doing surveys, and they're very suspicious of technology. So as we're thinking about how we move forward, whether it's in our leading smart cities or whether it's out into the most rural areas, I encourage all of y'all to think about not just kind of the big policy issues that we're wrangling with at the federal level, but also some hidden policy issues, unseen policy issues at the local level. So for example, how do you get counties and cities to work together? That's one of the most vexing policy issues I've ever run into. Or how do you build local technology leadership capacity in order to actually execute these projects, get them built, and really make the most use of them? That leadership, for better or worse, does not come and really cannot come from the big carriers or major corporations or government levels. It really almost has to be grassroots level. And in particular, as we're talking about the issue of privacy and how we gather and deal with people's information, this is not just an issue of kind of big picture, top-down policy. It really is a very real and relevant issue to folks in their normal day lives. I like to say that smart cities are really about citizen engagement and data, and privacy is where this comes together. This is really a core issue to launching the next generation of services and really making it something that everybody can take ownership in. So with that, bring up the panel. Thank you very much for your time, and thanks again, Deb, for this opportunity.
Well, I appreciate you all for coming. My name's David McCabe. I'm a technology reporter at Axios, and I know that right now I'm the only thing standing between you and lunch, so we'll try and keep it fun. So this is the privacy panel, and privacy obviously is sort of the watchword right now. I think it's sort of impossible to walk anywhere in town without stumbling into someone's privacy bill or someone's privacy white paper or someone's privacy panel. And so what I'm hoping we can do today is sort of lay out the state of play, where things stand, what the fault lines might be, have a discussion about those, talk a bit about potential areas for cooperation, and then have our great panel take your questions. So obviously, why are we here? We're at this moment in the conversation because last year the GDPR went into effect in Europe, and then legislators in California, in a sort of one-week attempt to avert a ballot measure apocalypse, created privacy legislation that goes into effect in January, which has put lawmakers here on the clock. That's sort of why we're here. We'll talk a bit about the state of play in a moment, but I'm hoping first that our panel can go down the line and introduce themselves, say who they are and where they work.
Sure. So I'm Neil Chilson. I am a senior research fellow at the Charles Koch Institute. where I had the tech and innovation portfolio. Prior to that, I was the chief technologist at the Federal Trade Commission and an advisor to Acting Chairman Olhausen, both in her acting chairman role and then previous to that when she was a commissioner at the FTC. And I've spent a lot of time working on privacy and data security issues from the FTC perspective, as well as from the telecom perspective from my previous life as a telecom attorney.
Ryan Clough, and I'm the General Counsel at Public Knowledge.
I'm Francella Ochillo. I am Vice President and General Counsel at the National Hispanic Media Coalition.
Hello, Laura Moy, Executive Director, Center on Privacy and Technology at Georgetown Law School.
And hopefully people remember me. My name is Will Rinehart, Director of Technology and Innovation Policy at the American Action Forum, where I focus primarily on rural broadband issues and privacy, security, and AI and platform regulation.
How could they forget you, Will?
No.
So I'm hoping we can start with sort of a jump ball, which is just where do things stand? What is the state of privacy regulation in America right now, at this moment, if you're a consumer? This is for anyone.
Well, so I'll talk from a little bit. I think there's often a perception that the U.S. doesn't have any privacy regulation. It's the Wild West. And that's not a correct perception. The U.S. has a wide number of sector-specific laws, including HIPAA, laws like COPPA that address specific audiences, and then it has a general federal framework for consumer protection under which the FTC has brought 500 privacy data security related cases. Of about 150 of those are specifically Section 5 general consumer protection privacy or data security cases. And so there's been a lot of enforcement in the US. I think that record stands up against any country in the world as far as privacy enforcement. And so it's not the Wild West. We're hearing a lot of discussions about it because the US is the leading area for tech innovation, and a lot of our companies involve consumer data. And so we're hearing a lot of talk about it, but it's certainly not an issue that the government hasn't addressed in the US before.
So I think it's right that there are existing laws on privacy, but there certainly are a lot of problems and a lot of deficits, right? I mean, we see, I think from a consumer standpoint, consumers have expressed a lot of outrage over the last couple years as we've seen breach after breach, major breach of data ranging from everyday information about activities that people may not consider to be highly sensitive to extremely sensitive financial data. We've seen missteps by major companies like the Cambridge Analytica scandal take place. We've seen and although we've seen a number of events like this, we've seen either an unwillingness or a failure or a lack of ability by major agencies to be able to enforce what seem to be existing laws that, in theory at least, could cover some of these practices, right? And when they do act, agencies sometimes lack the enforcement tools that they need to really create change. So while I agree that there are some existing privacy laws, I think that from a consumer standpoint, there are some real shortcomings to the current legal standard and to the enforcement atmosphere.
And Will, do you have something?
And the other thing that I think is important is that there's also kind of, I don't want to say I don't know if noose is the right word, but there is a very important law that California passed, as it's been alluded to, California Consumer Protection Act, that will go in effect in 2020. So the thing, and I think the tension that we're really seeing here in Washington, D.C. is whether or not in this year, in this Congress, if there's going to be any action on federal privacy, and what that would look like and what that necessarily means. So there's this kind of friction that if California does have this law, it will be taking effect in 2020, in the very beginning of the year. The question I think that a lot of people here in D.C. are trying to understand is if there's going to be a federal law and really what it should look like. And I know that we're trying to tease out some of those questions as well here.
And Francella, I'm wondering if you might be able to dig into this a little bit more. What does a patchwork of regulations mean? What's the impact? I think it's something that business interests say a lot. People say a lot. What does it actually mean, and what would it mean for regular people?
Well, I think it depends on which side of the aisle that you sit on. Mm-hmm. And I feel like there are going to be a lot of companies who say, we're all for consumer privacy, but we don't want a patchwork solution where states are able to come up with all of these different solutions. We want one federal regulatory framework. I think what concerns some advocates is that, number one, who's developing this regulatory framework? What are the voices? Who are the voices at the table that are going to be considered? Are we thinking about the large percentage of it's still over 10% of the country that has no internet access, which means that they have limited digital literacy, meaning that are they able to understand some of these disclaimers and notices and things like that? So is it worth having them? I mean, there are lots of questions that we're trying to tease out, and I think that before we can really decide on whether or not there should be one federal solution or not, we have to really think about, well, what does that federal solution look like? Because it's very difficult to say that states shouldn't have the right to do more for their citizens where federal regulations are silent.
Yeah, and we're definitely going to talk more about that. I want to quickly dive in on one thing. Laura, you talked a little about some of the harms we might see in this space, whether it's Cambridge Analytica. I'm wondering if anyone wants to say anything about how privacy or data use can play out in a discriminatory way, or how we might see divides perpetuated between communities by the use of data or by the way privacy is enforced.
Sure. So there's enormous potential. There's enormous potential upsides for all kinds of big data uses, and certainly machine learning, which is, I think, what today we would call AI in the existing technology. There's also enormous potential for systemic discrimination of all kinds, not just from sort of flawed data sets that don't accurately reflect populations, including, I think, some of the reasons that Francella mentioned, but also because there are sort of even deeper inherent fairness questions in essentially what some law professors have referred to machine learning as essentially an actuarial as opposed to clinical process, which means that individuals in all sorts of decisions, including really important decisions potentially about finance, health, housing, employment, really critical life areas, are being treated according to group characteristics fundamentally, even if it's very precise and very complex group characteristics, still group characteristics, as opposed to a very individualized and sort of human-led judgment. And that's not to say that human judgment can't be very biased. Obviously it can, but I do think that there's a lot of complexity and risks of opacity in a lot of these big data systems that really make the potential for discrimination pretty scary, and it's one of, I think, the major sort of overarching issues that hangs over this quote-unquote privacy debate, which is really about more than privacy. It's about the regulation of data use and data harms in all kinds of ways, and I think a huge question is how much any legislation would get into and address that risk.
And also, it's important to highlight that, just based on what Ryan said, the people who are often affected the most have the least amount of recourse. So the people who have higher incomes usually have more opportunities for redress, and the people who are usually disproportionately affected have fewer opportunities to either correct that information, to actually have anyone to actually reach out to.
Yeah, and I think I just want to second that, but I also wanted to add on just as a point to think about. We're not just talking about automated decision-making and potentially biased automated decision-making to directly affect whether or not people are eligible or selected for educational opportunities, job opportunities, healthcare opportunities, which is certainly a problem. But we're also talking about the advertisement, the elevation of opportunities to people about these things in the very first place. I mean, whether or not one is eligible for a job is a secondary determination that can only be made after that person applies for a job. And a person can only apply for a job if they're made aware of the opportunity in the first place. So, you know, there are certain types of commercial data use that could lead to certain opportunities being made available, being elevated to only certain portions of the population and not to other portions of the population. And I think that that is something that we're very concerned about as a potential privacy-related harm.
So,
yeah, I might just jump in. I think this is a really good example so far of how broad the discussion about privacy has become, and when we talk about federal legislation, how challenging it's going to be to get there. We've heard about data breaches, which at least most of the data that I've seen suggests that data breaches and identity theft and credit card fraud are the things that consumers put as their #1 concern as far as privacy, but we've heard a whole other range of potential harms. And so I think it's really important in this discussion, if we're going to make it anywhere in Congress, let's identify what the specific problem is, not just what the solutions look like, but what problems, what harms to consumers are we really worried about? And we're probably worried about some more than others, and how do we rank those, and how do we engage with those on the trade-offs that are going to come to those? even the big data analysis is not a one-way street. You can use big data analysis lots of different ways, including identifying people who have not gotten opportunities, who totally deserve them, on an equal playing field with other people. And so there's a lot of issues here. We want to make sure that we don't tie up the use of data in ways that could benefit everybody, especially disadvantaged populations. And I think that starts with thinking really hard about what specific harms to consumers that we're worried about.
So one way I'd actually love to get at that is ask you all, you don't all have to weigh in, but like sort of a jump ball. What harms shouldn't be in any sort of national privacy? Like what should lawmakers just say, like, we're not going to touch it. We're not going to go there. Or what shouldn't be there because it just doesn't make substantive sense?
Well, I'll just say two things on that point. One is, I think that if we're talking about data use regulation, direct data use regulation, which I personally think is going to be necessary and critical to addressing a lot of these risks, including discrimination. It's not the only solution. Obviously, there's lots of discussions about data collection regulation, consent mechanisms, data processing regulation of all kinds. But I think that a lot of that's going to be necessarily sector-specific. It builds certainly on what Neil mentioned is the existing patchwork of sector-specific laws, some of which may need to be greatly built out in the coming decades. But I think that it would potentially be a mistake to view this one bill or whatever comes out of the next probably multiple years of discussion as the be-all, end-all of all data use regulations. I mean, there's just no way that a single bill can address that. Now, I do think giving the FTC potentially broad regulatory authority to address different types of unfair discrimination, I mean, we can get into that. That's a very useful backstop and broad principle, but it shouldn't be, this is where you get into the question of like, should it preempt all other authorities? And it's like, well, no, because we don't even know the full universe of harms. And that's the other thing I'll just quickly say is, I'm on board with the idea of trying to identify with some precision or rigor the goals of the legislation, sort of what values or interests are we trying to protect. What I'm against is taking a too narrow or reductive definition of the very specific types or examples of harms, because a lot of this is still early days, certainly in terms of how machine learning will get built out. And so if you have an overly restrictive definition, you say we only care about like financially concrete injuries as opposed to other types of injuries, then that starts to be problematic as opposed to identifying broader values that we are trying to like protect specifically.
Yeah, I think I might just jump in a little bit and say that I agree. There's probably a wide range of harms that different tools are best suited to. There are probably some harms that we know now, financial harms that we know now that we can address with some clarity in legislation. There might be other types of harms where we might want to take more of a FTC enforcement type measure where we look at the cases as they come up and see how do they meet the balance between different interests. And on that, you know, it's pretty. I lost my train of thought a little bit. Maybe I'll come back to it in a bit. But I do think it's really important to think about what specific tools we use because there's a wide range of types of legislation and types of enforcement that the government could use to address harms to consumers.
Yeah, we're going to get to a specific conversation about venue, but Will, you had something to...
Yeah, I was just going to say that the FTC tried to outline at least some of the items that they would consider harms under their informational injury report, and they did list a couple of them, specifically, you know, sensitive medical information, identity theft, doxing, disclosure of private information, sexual orientation, and gendered identity questions. So those were generally the things that they were concerned about most. And I think that I mean, there's other things that obviously could be included, but the FTC has done, I think, a pretty good job of trying to outline at least some of the questions of harm that we would be concerned about with a potential privacy bill.
One thing I do want to say is that I do agree that the FTC has made some efforts. Yes, I agree with that. What I totally disagree with is the idea that us waiting to definitively identify a specific problem means that we shouldn't actually be thinking about what does thoughtful legislation look like today. Because the issue is that every time I open up a New York Times article or see on Good Morning America or get an email from, oh, you went to this hotel, your credit card might have been shared, or, oh, we shared this information on this platform, it's not enough for us to just wait and keep saying we haven't clearly identified the problem, because you have these large populations of people who have very little opportunity to do anything about it, to take control of their data. And the truth is that we're talking about this in 2018 when this is still a very new problem. As was mentioned before, this is a problem. We don't have any longitudinal studies on what this is gonna be like if decades after decades your data is constantly being manipulated, or maybe to spare that small business where these companies will say, oh, it's gonna hurt small business if we create legislation, but then the problem is that small business is still collecting my data. That small business didn't have the money to, implement the internal controls. That small business shared my information, and then after the data breach, that small business already collected on sharing my information, and I'm the one who has the harm. So now what? So I think that we have to put this into, as Commissioner Rosenworcel said earlier, to really think about simplicity. Like, are people being protected? Who are you sharing my information with? Do the people that you're sharing my information with have to comply with the same standards? Like, asking really basic, fundamental questions about caring for consumers. And if we don't come up with some sort of consumer-centric regulation or some sort of redress, then we're still sitting here and we haven't done anything.
I guess one thing that I've struggled with in our coverage as we sort of work through this is, like, how do you do that for not just all the technologies and instances which exist today, some of which you just identified, from the hotel to news site to a small business, but how do you make sure it's adaptable for even the future uses of technology we know are coming? Like, I've written a bit about the way the brick and mortar world collects data. So, right, I mean, one of those Amazon Go convenience stores where you walk in and you sign in and then you can walk out without interacting with a cashier uses hundreds of cameras. And they say there are privacy protections and that they don't use facial recognition. But, like, very broadly, how do you go about writing a bill that can adapt to both the foreseen uses of data that aren't so common yet and the ones that aren't foreseen?
So I think that one thing that is really of critical importance here, and that is sort of a fault line, you were asking about fault lines before, in the privacy debate, is agency rulemaking, right? The rulemaking authority for an expert agency that has the ability to exercise a sort of regulatory agility that you're talking about. We may have noticed that Congress doesn't always act, even perhaps when the stakes are really high, and even when there's a lot of political will to do something, it can be very difficult to change the law or to pass a law. That is absolutely the case with privacy. It is going to be the case even after we get a federal privacy law. And we need the ability for the law to change and shift as technology changes, as you're saying. Something that is happening right now is that states are iterating on privacy, data security, and breach notification for sure. States are doing a lot of thinking on this issue. State legislatures are coming up with new ways to address what they see as shifting threats in a changing technological environment. For example, with data security and breach notification, we see multiple states every year pass laws updating their existing statutes. For example, adjusting the category of protected information that's protected under their state data security and breach notification law. That's because data security threats change over time. For example, medical identity theft wasn't a huge threat maybe 15 years ago, but in the last decade has become a major threat, a major security threat, and as a result, a number of states have responded by updating their data security and breach notification laws to pull in information about one's medical history under the umbrella of data security and breach notification obligations. That type of regulatory agility is much needed. It helps establish a standard that responds to a shifting environment. So if we're talking about a federal law, I think that the options here are set a floor, not a ceiling. So, sorry, skipping ahead a little bit to the preemption discussion, but set a floor, not a ceiling, so that states can continue to iterate. Or, you know, if there's going to be preemption, which I think is a discussion that we can certainly get to, there's going to have to be some type of alternative to the regulatory agility mechanism that exists in state legislation right now, and that's going to be robust rulemaking authority for an expert agency that is able to assess the shifting technological environment and to respond.
I would be curious, Neil, just to quickly hear your thoughts, because I suspect they may be different. You obviously have a background at the FTC.
Well, so I did think about, I did remember, you mentioned Commissioner Rosenworcel. I remembered the other thing that I was going to say, which is I really liked her quote about how are you supposed to manage something you can't measure? And if our ultimate goal, and there may be disagreement on this, but and getting to your question, I think part of the way you maintain flexibility is look for the common goals. Like, what are we really trying to do here all together? And if our main goal is to protect consumers from injuries, we should have a robust discussion in Congress about what injury is and what injuries we're trying to address, because I think that's where all of the political dynamics will get played out. And injury, that definition doesn't change as fast, right? So the technologies can change around, but we have an innate sense about what consumer protection is. And we can put mandates out that say to a federal agency, here's some guidelines on what you're supposed to do. Section 5 of the FTC Act is a great example of that. It talks about unfairness and deception. These are very high-level principles, and the Commission has applied them over the last 100 years. And in the last 25 years, it's applied them in the privacy and data security space. There might be ways it can do it better, but it is an example of the flexibility that can come from an enforcement-driven approach rather than, as Laura said, where a state legislature writes a bill and then they realize, oh, well, the world has changed, we got to rewrite the bill. We got to rewrite the bill again because they're writing the sort of checklist of things that companies have to do. That approach is very challenging to keep up to date when technology changes, and in part because legislatures are never going to be the tech experts that the tech companies are, and so they're always going to be playing catch up, so it's challenging.
So I think this point is crucial, so I just want to respond on a couple of things. So I would just echo what Laura, I think the phrase is actually perfect, the floor versus the ceiling question, right? I think that one question is why, and I think we should separate the preemption of state issue question from the question of how broad a federal rulemaking authority should be or federal enforcement authority, because they are potentially somewhat separate. So just looking at the federal level for right now, the answer, the one question for any advocates of, or actually for Neil specifically, is do you really need to constrain the FTC's definition in the future of what injuries it could potentially consider and be trying to prevent? I mean, concepts like unfairness, I agree, are very useful as long as they provide actual legal, like practically useful authority to address an incredibly wide range of situations. Now, you get a lot of people say, oh, well, you know, you've got this potential for overregulation. I think in practice, the experience of the FTC and certainly congressional reactions to quote-unquote overregulation show that those concerns are often overblown. But the point, I guess I just don't see the case for limiting the FTC's authority on like specific types of injuries.
I think that's a really great way to put it. And my only response would be, again, to point to the Rosenworcel quote, how will we measure success? How will we know whether or not the FTC has protected consumer privacy better? So we should probably focus on the types of harms that we can actually judge whether or not they're doing a good job. Those will be the ones that are most salient to consumers in the first place, and it makes the most sense to do that because our ultimate goal is to make consumers better off. And the thing we haven't talked about yet, but we should, and Congress should very much so, is that a recognition that these regulations, they come at a cost of some kind, right? There's trade-offs. Cost is probably the wrong word. There's trade-offs to these. We need to engage on those trade-offs. It's really important. And so to the extent that there's limits on the FTC's ability to define harms, we want to focus around which harms are the ones that come with the best trade-off trade-offs. And so that's the question. I don't know the answer, but that seems to me like the right question for Congress to be asking. How are we going to make sure we're making consumers better off? And that tends to be, let's target harms that can be measured, where we can quantify whether or not the FTC is doing a good job, or the other regulators.
And I don't want to monopolize this. I guess I would just very briefly say that, like, there's a difference between Congress also identifying particular harms that it wants measured, prioritized, and mandated to be addressed. But that's not necessarily the same thing as completely constraining the FTC's authority to act on a particular, on a broader potential range, especially as others have said, this really, any bill that passes is going to be probably the foundation for decades of agency authority with little future congressional action.
And I just, on the question of injuries, I also just want to point out that historically, we've kind of thought of privacy violations and privacy injury as taking place on an individualistic basis, right? We're thinking about the harm to the individual. And I think that some of the problems that we're starting to notice that may relate to some of the new emerging uses of or some emerging commercial data practices are really societal harms, right? We're noticing that opportunities may be less available to certain segments of the population, and that may be exacerbating existing social disparities. We're noticing that some of the that some methods of content distribution could lead to exacerbation of existing political divides and partisanship. We're noticing that some of the some ways of prioritizing certain data over others could lead to amplification of false information or careless journalism, right? We're seeing some of these things that may lead to societal harms. And so while I agree that it is important for us to come up with some way to articulate what the harms may be, and to measure some of those harms, we may also be looking at harms that we haven't historically been looking at, and we need to figure out new ways to measure those, and we may need to task an agency with looking at those things and with identifying a framework that can start to address some of those societal harms.
But also to kind of follow up on that, the one thing that I do worry about the current agenda in Congress, and I know it really hasn't obviously been solidified all that well, is that at least on the House side, the House Democrats have said pretty specifically that they aren't really particularly interested right now in doing the kinds of hearings that I thought were actually kind of somewhat helpful the end of last year. In particular, the ones with the FTC commissioners talking through their kind of authority and what they thought were the gaps in their own the tools that their agency had and didn't have. I thought that was actually very, very good. I believe it was on the Senate side of things, but all this is really to say that there is this opportunity for us to actually kind of go back and see, okay, what were the issues with Cambridge Analytica that were not necessarily solved or could not necessarily be solved by the FTC or by another regulatory agency that actually do harm consumers. So,
and just the FTC has not yet weighed in on the Cambridge.
No, of course not. Of course not. Yeah, they are currently investigating the case, and they probably will. That does make this a little bit difficult, to be very honest, that they can't speak about these cases. But I think there could be an interesting place that a well-structured hearing that brings together many of the people that are on this panel to talk through what are some of the actual concerns that we really truly do have. Where are the gaps that we're talking, where are the gaps of agency problems? But more importantly, where are these specific things that have happened in the last 2 years that we're all generally concerned about? The notification of consumers that they're, especially with the Cambridge Analytica issue, one of the big things is that it seems that Facebook had knowledge that consumers' information was shared for many years, but didn't actually tell them that it was being used in a way that they might not necessarily have agreed with via Cambridge Analytica. And just that the question right there is, well, how do you structure a data breach notification law at the federal level that could target these kinds of questions? I haven't really seen that type of conversation occur in Congress, and I would love to see it occur to pinpoint the problems that we've had in the past and very specifically see where the current gaps in federal legislation exist. Because they do exist, but I don't think they're as substantial as we often think that they are.
I think the one thing that I want to, I totally agree with most of what you said. One thing that I want to make sure that we avoid is turning this into a partisan issue because of the fact that when we are working through whether or not notice is adequate, do people really understand their disclosures? If only 1 in 1,000 people who get a privacy notification actually click on it, does a company really have an obligation to really be honest about how they're going to use their information if nobody's going to read it anyway? These are like some of the questions that I think we need to have like an authentic conversation about just as consumers. Are we protected? What is it that we're asking for? Like to really have a thorough conversation without it turning into, well, certain Republican offices aren't going to get behind it or certain Democratic offices aren't going to get behind it. That worries me because, quite frankly, the conversation is already with a limited orbit of people. There are obviously going to be a lot of people with corporate interests who are going to have a lot of money and a lot of support to push through their ideas, and there are going to be a lot of advocates who are speaking for a smaller group of people who are often silenced in these policy-making discussions. So I just want to make sure that we're constantly thinking about this as a bipartisan issue, that it doesn't really matter what community you come from. We all want our data to be protected.
Just to follow up on that, I'm sort of curious, and you alluded in the beginning sort of to if there's going to be preemption, and we can, to get into the preemption discussion, if there's going to be preemption, it has to be, it's a serious thing to do. And I'm wondering how you think you go about having that conversation and talking about what is the floor. If there's going to be a floor in a way that doesn't immediately become, well, this is about finding the line between what Democrats are willing to preempt on and what Republicans are willing to give up. Because I feel like that's what I hear on the Hill all the time.
Well, quite frankly, I think that it is way too early for us to actually make a decision on whether or not states should be preempted because we don't even know what exactly is the baseline. We have no idea because as much as we're talking about, some people feel like, well, we haven't had any of these discussions. Some people have already drafted legislation. I've read it. So I'm kind of like, some people have decided on what they want this to look like. So I think that we are fooling ourselves if we're saying that we really haven't like put serious thought into it. I think that the truth is that we haven't really agreed on what it should look like. In terms of like whether or not states should have the option to step up in the absence of federal regulation, I wholeheartedly believe that right now. But I also think that once we see what something that's closer to final looks like, I think that we should all be willing to compromise because that might change when we start seeing something on paper.
Yeah, just a quick, because I think it might be useful for the audience. What are there states in particular you're watching throughout this year in particular? Or anyone of them?
I don't have.
I don't mean.
I was studying in California, but yes.
New York City, interestingly enough, has said that they want to actually do something, which to me is, I wouldn't say worrying, but worrying, because then you got cities doing it as well. I would probably expect Washington, because now, I mean, this right now, we're the state legislature.
Washington State.
Washington State, yes, not this current Washington. So I'd probably expect that, and then probably something in Illinois. I'm going back. I'm from Illinois originally, so I'm going back to actually talk to some people here in the next next month or so to figure out what they're interested in, because I know that has been something that has been bandied about. I would expect kind of the major players to be starting to talk about this, and I know at least in Washington State, I don't know if there has been a draft bill, but I know that there has been conversation about doing this, and New York City specifically has filed comments saying that they are going to work on this in the next year, 2 years. So it's coming.
On the broader preemption question, and I sort of think you're exactly right. Like, it is very early to say yes or no. But Laura, I'm curious. When you did say there sort of has to be a floor, I'm wondering what, as you sort of think about this question, what are the lines for you? How are you starting to draw them, even if they're not kind of firm in the sand?
So I'm gonna answer a slightly different question because I think that I don't want to articulate all of the elements that that belong in a privacy bill, but I think that we can agree on some of the low-hanging fruit. Or not, maybe not agree, but we can name some of the things that I view as low-hanging fruit based on things that we agree have been problems over the last couple years. One of the really big problems over the last several years has been a lack of strong enforcement authority by agencies that are tasked with enforcing privacy, and not even specifically tasked with enforcing privacy, but have become the de facto privacy enforcers through policy developments over the course of decades. And that is to say that the FTC really, although it has Section 5 authority, and maybe has a lot of additional authority through consent decrees that it has negotiated with major companies, even when violations take place, lacks the ability to take action that really will force changes in the future. And just as an example, when Google was found to have violated the consent decree, I think back in 2012, the penalty that the FTC was able to levy against Google amounted to about 5 hours of revenue for the company, right? So five hours of revenue of a company is not going to incentivize change, broad, massive change on the scale that I think consumers are demanding. So just thinking about some of the things, some of our existing framework without even formulating a completely new framework that might exist in innovative privacy legislation to come, just looking under our existing framework and identifying the deficits. One of the really big ones is enforcement authority. I think technical expertise has been mentioned. So maybe giving some of the existing agencies that we have additional resources, additional technical expertise, and truly strong enforcement tools that will enable them to make privacy into a boardroom level discussion.
And I want to just prepare the audience. We're going to go to questions relatively soon, so start thinking about where you want to take them. I'm curious. I want to get at something that we talked about when we sort of all pre-gamed this panel, which is I think there's a perception, some of it fair, some of it not, in the public that like people on Capitol Hill don't have any sense of these issues. And I think that's just not true. Like, I talk to staffers all day, and you all talk to staffers all day. And there are probably some very smart staffers in the audience. I'd be curious, though, to hear, what do you think Congress still needs to learn and understand to be able to get this issue right?
One thing that I immediately am thinking of and I visit Hill offices often, I don't think that everybody has really grasped how this affects third-party vendors who do not collect consent. So I think a lot of the times we talk about the initial contact between consumer and the company, where you might check that box or yes, I agree. But once that information is either sold or shared to a third party and then often to other parties thereafter, there are very few constraints on how that information is used, and I don't necessarily feel like that's been a great conversation with offices.
This is like what we just saw with the story on the telcos and the location data sharing.
It might be geolocation data sharing. It might be the way that your information is packaged to come up with profiles for you as a consumer, like this person's likely to buy at this time of day, buy this dress, based on your cookies and things like that.
Mm-hmm. I think Congress could learn a lot around the connection between the information streams that are flowing about on the internet and the business models that the companies use. I think that's very complicated. It's deeply complex, and it's very difficult to parse out even for people who are in the industry. Understanding the legislative impacts or the impacts of cutting those off or redirecting those streams, I think would be really important for Congress to weigh those trade-offs. I mean, they would need to know, how is this going to affect ad revenue or ad-supported websites on the internet? I think those are all really important questions, and I think Congress could learn a lot there.
So I'll just add two things quickly. One, this might not apply to the few offices that are probably the most engaged in privacy. It's hard to generalize across Congress as a whole. But I will say that in general, I do think that there still is lag both in the public and in Congress of thinking about the privacy debate as really what we traditionally think of as privacy, which is important, to be clear, which is like trying to stop people from finding out things about you or otherwise keeping your information private. And that's an important value and goal, but it is far, as I think this conversation shows, from the entirety of what the privacy debate has really become. And it's really crucial for Congress to understand that. The second thing, on a slightly more detailed level, is just I do think it's important for Congress to really think about consent mechanisms and the reality of consent mechanisms as opposed to just in the abstract. There's all kinds of interesting studies and data around both the pitfalls of these long privacy policies that are never read by consumers. And I just think it's really important that Congress be rigorous about how those mechanisms play out in the real world, which frankly cuts both ways in this debate, because I do think privacy advocates can be demanding sometimes requirements that are not that useful, but at the same time, it's also really important to realize how easy it is for companies to manipulate the very, very precise details of consent mechanisms in ways that render them practically useless.
The one last thing, and this is kind of following on what Neil said, is that in some ways, I kind of don't hope for preemption, because then we have a bit of an experiment that actually occurs within California in the way that we are now seeing experiments with GDPR and its application in the EU. I mean, there's been some really, really interesting research from privacy economists who are working in this space that effectively found that GDPR decreased by some almost 40% investment VC-backed funds or VC-backed deals in the wake of the GDPR implementation. So in a way, really, to be more clear about this, there's clearly costs that are going to be borne by somebody, and the question is who is going to bear the costs and at what level. I think that we need to agree, or at least I think we shouldn't fool ourselves in thinking this is going to be a costless endeavor. There are going to be costs, but I think we should be very abundantly clear about those kinds of costs, and and celebrate the trade-offs, not necessarily try to bury them in a conversation and rhetoric.
I think that there are three things that I would note as things that that Congress should be thinking about that I don't hear discussed enough. So one is that the distinction between sensitive information and non-sensitive information is rapidly disappearing, right? Just that information that we have traditionally thought of as not sensitive can be used to draw inferences about one's private life that are extremely sensitive and extremely private to that individual. The second is that I think that there is a difference between information sharing by a consumer that is unavoidable versus information sharing that is avoidable, where a consumer can make a choice. And where a consumer really has no choice but to share information with an entity with whom she is sharing information, then the privacy standards have to be higher. And that's one reason that it makes sense that we have privacy laws that exist in the areas of healthcare, education, and finance, right? These are areas where we want people to be seeking services, getting services, and sharing information. There are exchanges of information that are taking place on the internet that as well are becoming unavoidable for consumers. And in those areas, we might want to think about how heightened privacy standards should apply. And then the third thing is more broadly, and kind of adding on to something that Ryan was saying, is that I think that there is not a full acknowledgement yet that privacy really is a civil rights issue, right? That the commercial data practices can be used, that certain commercial data practices can exacerbate existing social disparities, and in a way that that it may not be what we want for the future. And so we need to really bring that conversation into conversations about privacy, and we should see greater engagement with the civil rights community as well from the Hill on these issues.
Those were all really, really great, and I hope helpful to people in the audience who are working on this. We have a couple more minutes for questions, so I'll open up the floor if anyone.
Can I kick us off with a Twitter question?
Yes.
Great. So a Twitter user asks, what are some of the common bipartisan goals of personal data privacy, such as consumer protection? I'm going to tie that to a second question, which is, in the event of a data breach, how can we make sure that consumers are aware of the harm they've experienced?
Well, I think in responding to that, I'll also bank shot off of Laura's question, because I think it's a really good point about sensitive, non-sensitive data. I think at the FTC, that's always essentially been a proxy for consumer injury. It's more in the sensitive data area that we have injury that will meet the unfairness test, for example. And so I think areas of bipartisan consensus around consumer injury, I think we can find those. I think it's pretty easy, actually. We can look at the ones that are very popular around financial health, safety, children protection, And those should be the areas where I think we can make the easier lifts. I think when we start talking about social harms, we're going to have to ask ourselves: do we want a privacy bill that's also trying to address election issues or press issues or some of the discriminatory issues? We have frameworks for some of those issues already. Maybe those are better vehicles for those types of societal concerns than a privacy consumer protection frame. And so I think maybe in the privacy debate, it's important to find those areas of commonality, and I think we have some of them, and I think that's where we should stick to the discussion. I mean, we should talk about everything that's important, but I think that's where we have the best likelihood of moving something forward.
And to the second part of your question, right now, companies have very little requirements about notice. And basically, like, what happens if you're the person that gets the email saying, we shared your information 3 weeks ago, somebody might be using your credit card right now. So I think that, we definitely agree on, companies actually having some sort of regulations and also a time limit to say you have to notify people within a certain amount of time that's reasonable. And right now, it just doesn't seem like there's anything.
And I know I saw you first, and then we may, unfortunately, have to wrap up.
A frustration with the privacy agreements, terms of service agreements, is that if you have the stamina to read through the 10 or 15,000 words that they constitute, you get to the very end, and the last thing is they reserve the right to make changes whenever they want, and continued use implies continued consent. And there's no notification requirement of we're making a change. There's no restriction on changes that they can make. So what's the point?
Well, I would say to that, that's, the whole notice part, at least from the FTC's view, is all about deception. That's one half of the authority. If you still harm consumers without a justification, without a benefit to consumers or to competition, and in a way that they can't avoid, you're still violating the FTC Act. And so outside of, it doesn't matter how complex your provisions or your terms of service are, or how broad they are, if you harm consumers without, you can still violate Section 5. So.
But the problem with that is that the FCC right now is still relatively a reactionary agency. So the thing is, if there's an individual harm, you don't have individual redress. You usually have to wait until there's a certain amount of harms, and then the FTC acts, which is another problem.
I think so. I share your frustration. I think that there are certain instances where where a company has been found to have an affirmative obligation to notify consumers that the policy has changed. Right. I think that the Vizio case was one of those. Right. Essentially, where someone correct me if I'm mistaken, but I think where TVs were collecting information about what people were viewing, and the FTC found that the company had to do more than simply flash something up on the screen for 1 minute that disappeared, had to make an effort to notify consumers. But you still have the problem of a consumer having invested in a product, paid money for a product that they now have either to well, I guess in that case, they could decline to agree with the terms in that case. But in many cases, a consumer has already made an investment in a product or service, and it's very difficult for them to just abandon it because they don't like the changing practices. So the switching cost problem is a major one that I think just underscores the need for privacy legislation that not only focuses on enhanced notification and choice or control by the consumer, but that also prohibits certain unfair uses of data.
And I think that's going to be the last word. Before we go to lunch, if everyone on the panel wants to share maybe where someone can find your work online, if they want to read more of your work or see your tweets.
Follow our sponsors for today. I think they've been live tweeting, and so you can probably find me on there anyways, and probably all of them.
Public Knowledge's website, as well as our general Twitter account, which I believe is @publicknowledge.
NHMC, I haven't been posting today. I've been paying very close attention to the discussion.
I'm at Laura Moy on Twitter, and our center is at Georgetown CPT, Center on Privacy and Technology. And thanks again to our sponsors and hosts.
On Twitter at Will Rinehart, and then for all of my work, it's williamrinehart.com.
And can I do a quick plug? I actually read one of Will's
Oh, boy.
articles last night about opt-in versus opt-out, and I will
that was
tell
my
you,
rant.
I will tell you that I was almost persuaded by some interesting arguments that even I, as a skeptic, felt like it was worth reading again.
Well, we'll end
thank
on
you
that.
for
We'll
that.
end on that hopeful moment. And thank you to our sponsors. Thank you, Deb, for organizing this. And you can see my work at signup.axios.com, which I always joke at the end of these things is where you give us just a little bit of your personal data and we give you news. Thank you so much.